The moment my brother slid the paper across the kitchen table and said, "Just sign it, it's easier this way," I knew something was wrong. I just didn't know yet how wrong. My name is Lena. I'm 32 years old. I work as a forensic accountant for a mid-size firm in Ottawa, which means I spend my days finding the numbers people try to hide. The irony of what happened to my own family is not lost on me. It never will be. My father, a man named Harold, who built a modest but real estate portfolio across Eastern Ontario over 40 years, was diagnosed with early-stage vascular dementia in the March before all of this happened. He was 68. My mother had passed 6 years prior, ovarian cancer, quick and brutal, and after that it had always been the three of us, my father, my older brother Callum. No, wait, I need to stop. I keep using names from other chapters of my life. Let me start over with what matters. My brother. I'll call him by his name here because he doesn't deserve the protection of anonymity. His name is Boyd. Boyd is 4 years older than me, married to a woman named Trish, who has never once in 11 years of knowing me remembered how I take my coffee, and they have 2 kids who I genuinely love and who have nothing to do with what their father did. Boyd always had a relationship with money that I'd describe as urgent. Not poor. We weren't poor. None of us were. But Boyd treated money like it was oxygen, and he was always slightly suffocating. When Dad got the diagnosis, I moved back to Kingston. I subleased my Ottawa apartment, took a hybrid arrangement with my firm, and I moved into Dad's house on Rideau Terrace, the old brick one with the wraparound porch that smells like cedar in summer. Boyd stayed in Mississauga. He visited on long weekends sometimes. He sent grocery delivery orders that Dad didn't always know how to receive. He called every Sunday at noon, always for under 10 minutes. I was the one who took Dad to his neurology appointments at Kingston Health Sciences. I was the one who reorganized his medications into a weekly pill organizer, who called Service Canada to sort out his OAS and CPP adjustments, who sat with him on the porch in the evenings when the light was soft and he told me stories about my mother that I'd never heard before. Those evenings were a gift. I didn't know then how much I would need to hold on to them. Dad had a will. Of course he did. He was Harold Purcell, a man who kept a paper copy of his car insurance in 3 separate locations. The will had been drafted by a lawyer named Mr. Fenwick over on Princess Street, and the last version I knew of, which Dad had shown me the summer my mother died, split everything equally. The house, the 2 rental properties in Bath and Napanee, the investment accounts, the small self-directed RRSP he was still quietly adding to. Equal shares, Lena and Boyd. That was the will I knew about. What I didn't know, what I had absolutely no reason to suspect, was that Boyd had spent the 8 months since Dad's diagnosis doing something else entirely. The paper he slid across my father's kitchen table on a Thursday evening in November had the letterhead of a firm I didn't recognize. Beaumont and Lafleur, barristers and solicitors, with an address in Etobicoke. Not our family lawyer. Not Mr. Fenwick, who had been handling Dad's affairs for 2 decades. A firm I had never heard of, with a will I had never seen, that left Boyd 90% of the estate with a 10% disbursement to me. My father was sitting at the table too. He had a mug of tea in front of him. He was wearing his reading glasses and looking at the paper with an expression I'd seen him use when he was trying to seem engaged but had lost the thread. That expression had become more common. It broke my heart every time. "Dad," I said carefully, "have you seen this before?" He looked at me over his glasses. "Boyd says it's the updated one. He says the other one had some tax problems." I looked at Boyd. Boyd was very carefully not looking at me. "What tax problems?" I asked. "Lena." His voice had that tone, the one he'd been using since we were teenagers, the one that meant don't make this into a thing. Dad's lawyer explained it all. The previous structure would have created a significant capital gains liability on the rental properties. This restructures the disbursement to minimize that. You still get your share. 10% of 2 rental properties and an investment account is not my share, Boyd Addy. It's the tax-efficient share. Mr. Fenwick would have charged 3 times as much to get you to the same net outcome. I'm a forensic accountant. I have been for 8 years. The argument he was making was not entirely without logic, which was, I would later understand, intentional. He'd prepared for this conversation. He knew enough to make it sound plausible to someone who didn't know numbers. And he was betting, accurately, for about 48 hours, that I would be too exhausted and too grief-adjacent and too busy being the daughter who was actually here to push back immediately. I told him I needed to read it before anyone signed anything. He said that was fine. He was very relaxed about it. That was the second sign I missed. I didn't sleep that night. I read every page of that document with a highlighter and a notepad. The way I read financial statements when something feels wrong but I can't yet name it. And by 3 in the morning I had found what I was looking for. Not a tax restructure, a signature. My father's signature, dated 8 months ago, witnessed by 2 people I didn't know, notarized by a commissioner of oaths affiliated with the Beaumont and Lafleur firm. The date was 11 days after Dad's dementia diagnosis. I want to be clear about what that means under Ontario law because this matters. For a will to be valid, the testator must have testamentary capacity at the time of signing. They need to understand what a will is, what they own, who their family is, and what they're doing. 11 days after a dementia diagnosis is not automatically disqualifying. Early-stage dementia can coexist with legal capacity, but it is a flag, a significant one, and the fact that this will was executed not by our family lawyer but by a firm in Etobicoke that Boyd just happened to have a contact at was another flag. And the fact that I, Dad's primary caregiver for the better part of a year, had never once been informed this document existed, was a flag so large I could have wrapped it around the whole house. I put the document down on the kitchen table at 3:17 in the morning. The house was quiet. I could hear Dad's CPAP machine humming from the bedroom down the hall. I sat there in the dark and I made a decision. I was not going to sign anything, and I was not going to tell Boyd that yet. The next morning I called my firm in Ottawa. Not for work, I called my mentor there, a senior partner named Dr. Vasquez who had spent 15 years doing estate litigation consulting before she moved into forensic accounting. I told her what I had. She was quiet for a moment. Then she said, "Lena, don't touch that document again without gloves and call an estate litigator today." I want to be honest about what the next 3 weeks felt like. People talk about betrayal like it's a single moment, a clean cut. It isn't, it's a slow leak. Every time I looked at Boyd across my father's dinner table, I was cataloging things. The way he steered conversations away from the will. The way he was suddenly very interested in visiting more often, in being seen being a good son. The Sunday call with Dad that went 45 minutes instead of 10. He was building something the same way I was, and we both knew the other one was doing it, and neither of us said a word. I found an estate litigator through the Kingston Law Society referral service. Her name was Ms. Oduya, and she had an office on Brock Street and a handshake that told you immediately she did not lose very often. I brought her the document, a copy of Dad's original will from Mr. Fenwick, Dad's complete medical file from Kingston Health Sciences, including his initial cognitive assessment, and a log I had been keeping, quietly, daily, for months, of every appointment, every conversation, every medication adjustment, every lucid moment, and every hard one. I had kept the log because I am a forensic accountant and I keep records the way some people keep diaries. It turned out to be one of the most important things I had ever done. Ms. Oduya reviewed everything, and then she looked at me over her reading glasses and she said, "Your brother had this executed 11 days post-diagnosis, at a firm he sourced independently, without notifying you or the family solicitors, and with your father's signature witnessed by 2 individuals connected to that firm. We have grounds to challenge capacity, grounds to challenge undue influence, and depending on what we find in the execution process, potentially grounds to allege fraud on the court. Do you want to proceed?" I said yes. What I didn't expect was how much of the next part would hurt in ways that had nothing to do with money. Because here's the thing about Boyd. He's not a cartoon villain. He coached my soccer team when I was 9. He drove 8 hours through a February blizzard when I had my appendix out in my second year at Queen's. He's a person I have loved for my entire life, and somewhere in the grief of losing our mother and the fear of losing our father, He had decided that the answer was to take what he could before it was gone. I don't know how people get there. I don't know if I'll ever fully understand it. What I know is that understanding someone doesn't require you to let them take what isn't theirs. Miss Oduya filed the challenge to the will in February. Boyd was served at his home in Mississauga. Trish called me that same evening, crying, saying she had no idea, saying Boyd had told her the updated will was something Dad had wanted. I don't know if she was telling the truth. I chose to believe her, not because I was certain, but because her kids were going to need at least one parent who wasn't about to be consumed by a legal proceeding, and I needed to stay focused. Boyd called me the night after he was served. I didn't answer. He texted, "You're doing this to your own family." I read it once and put my phone face down on the kitchen counter. My father was still in the house. He was still doing reasonably well for where he was in the progression. He had good days and harder days, and on his good days he liked to do the crossword and listen to the CBC and ask me about my work without always following the answer. I told him there was a legal situation with the will that I was handling. He nodded like he understood. Whether he fully did, I'm not sure. I held his hand for a little while after that, and neither of us said anything. The discovery process is not dramatic. People who haven't been through litigation imagine it as confrontational and immediate, like a courtroom scene. What it actually is paper, endless, methodical paper. Miss Oduya requested the complete file from Beaumont and Lafleur. She requested the billing record. She requested the intake records, the instructions log, the capacity assessment protocol, the Commissioner of Oaths records. What came back was where the case broke open. The capacity assessment Beaumont and Lafleur claimed to have conducted prior to execution, a standard step a competent firm would take with an elderly client on a major estate document, was a single page, a checklist. 6 questions, all marked yes, with a timestamp showing the entire assessment had taken 11 minutes. 11 minutes to clear a 68-year-old dementia patient to sign a document restructuring a 7-figure estate. Dr. Vasquez, reviewing it remotely, told me she'd seen more rigorous intake procedures at a library card desk. But that wasn't the piece that ended it. The piece that ended it was Boyd's own email. During discovery, we obtained Boyd's communications with Beaumont and Lafleur going back 14 months before Dad's diagnosis. There was an email from Boyd to the managing partner at the firm, dated 6 weeks before Dad saw his neurologist for the first time, asking about the process for updating a parent's estate documents, and specifically asking whether there was a way to expedite the process if the parent's cooperation might be limited going forward. Limited cooperation, 6 weeks before the diagnosis, which meant Boyd had been anticipating the diagnosis, or had been told something from a preliminary appointment, and had begun planning around it before we even knew what we were dealing with. Miss Oduya said, in the dry professional tone she used for the most devastating information, "This establishes premeditation of undue influence prior to incapacitation. This is no longer a capacity challenge. This is a will validity challenge with fraud elements." I sat in her office on Brock Street on a Wednesday afternoon in April, and I stared at the wall for a little while. Outside, the Cataraqui River was breaking up from winter. I could hear it if I was quiet enough. Boyd's lawyer reached out 2 weeks later. Boyd wanted to settle. I told Ms. Oduya to tell them I was listening. What Boyd's lawyer proposed was a return to the original 50-50 split, with Boyd covering the legal costs on both sides, with a signed acknowledgement that the November will was invalid and would be destroyed, with no further challenge from Boyd to any subsequent estate proceedings. It wasn't everything. He wasn't going to face criminal charges because proving criminal fraud in an estate case in Ontario requires a threshold that this, despite everything, didn't quite meet. He wasn't going to be disbarred from anything because he's not a lawyer. He was going to walk back to Mississauga and explain something to his wife and children and live with what he'd done. That was the consequence. I thought about it for 48 hours. I talked to Ms. Oduya. I talked to Dr. Vasquez. I talked to my father on a Tuesday morning while we were sitting on the porch, and I told him, in the simplest terms, that I had protected his wishes. He reached over and patted my hand and said, "You've always been careful, Lena. Like your mother." I accepted the settlement. The Beaumont and Lafleur firm received a formal complaint to the Law Society of Ontario, filed by Ms. Oduya, detailing the capacity assessment failure and the conflict of interest in their relationship with Boyd. That complaint is pending. The 2 witnesses to the signing were also flagged. Whether anything further comes of it is not something I can control. What I can tell you is this: Boyd and I haven't spoken since the settlement was signed. Not because I formally ended contact. There was no dramatic confrontation, no last conversation where I said everything I needed to say. He stopped reaching out and I stopped reaching back, and somewhere in that we've found a kind of answer neither of us put into words. My father is still in the Kingston house. He's in a different stage of things now. We've added a part-time PSW from home and community care, a quiet woman named June who makes him oatmeal the way he likes it and knows which CBC afternoon shows he prefers. On his good days, he still does the crossword slower now, but still. On harder days, I sit with him on the porch and we watch the light change over the yard and I tell him about the week, what I've been working on, the weather, whatever I can find that keeps him tethered to the present for a few minutes longer. It's not the story I would have written for us. It's not the end of anything I wanted to have to fight, but my mother raised 2 children and one of them, faced with grief and fear and the arithmetic of inheritance, chose to protect what mattered. I think she would have recognized which one.